I'm Walter Isaacson. I'm here with Professor Joseph Ellis. We've been talking about the Constitution. I think a lot of people think the Constitution does things like says, you don't have to testify against, yourself, and you have a right to free speech. But that's not actually in the Constitution.
It's in the first 10 amendments to the Constitution, which are called the Bill of Rights. And whereas we can plausibly argue that Madison is the father of the Constitution, maybe Gouverneur Morris deserves some mention too, there's no question Madison is the author of the Bill of Rights.
Tell us why the Bill of Rights was separate.
It's a codicil to the document, you're right. It's a kind of epilogue. Even though for a lot of people in America and outside, if you cite something from the Constitution, they'd all pick something from what is really the Bill of Rights. Here is the prosaic truth of it all. When the state ratifying conventions met throughout 87 and 88, 7 of them ratified but with amendments, suggesting amendments to the Constitution.
So by 1788, we'd got most of the states willing to sign on to the Constitution, but they had said, hey, you need to make it a little bit better.
The amendments were not conditional, but the amendments were recommendations. Madison made a big point about this. Anyway, turns out there are 124 amendments, recommended. Now, some of them repeat each other.
It's good to get them down to 10.
But Madison says, look, in order to assure the full participation of all the states, especially you take about like Rhode Island, still hasn't even signed, North Carolina's lingering. New York really signed against its will. We want to get them inside the big tent. We need to say, we've listened to you.
And so what do? They meet in Philadelphia and write a Bill of Rights?
No, the government is in New York, and it's being written by Madison, who's then a member of the House of Representatives, on his own time.
Mm-hmm. And so let's go through them. It says Amendment 1 may be the most famous. It's Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or the press or the right of the people to assemble.
Boy, that's got a lot in it. That collapses like 6 of the recommended amendments. You can see 2 things working together then. One is Magna Carta. Some of these are the very rights that have come from, medieval England and have a great history, and Americans are aware of those. And many of the state constitutions have this stuff in them, in the preface. The religion, that's a different thing. Madison and Jefferson together are responsible for the most revolutionary, radical proposal in Virginia politics that becomes the basis for this, the total separation of church and state.
Before then, a lot of the colonies and then states had an established religion.
That's right. Virginia had episcopacy, Massachusetts had Congregationalism.
Maryland was Catholic, right?
Maryland was Catholic. And in those states, when you paid your taxes, for example, in Massachusetts, a part of your taxes were going to support the congregational minister.
And does this also mean that pure freedom of religion, or does it just mean there won't be an establishment of a church?
In the version, it's in the Virginia Constitution, it's total freedom. And Jefferson's really clear about that. Religion is a personal matter. It's a matter of conscience, and that you're free to pursue that in whatever way you wish to, as long as you're not harming anybody else. But the Second Amendment is controversial even as we speak.
The Second Amendment, which is probably could be a Trivial Pursuits test for some people,
Yeah.
is the one that says a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This has so many clauses and commas that we're still debating on. What did they really mean by the right to bear arms? Is that a well-regulated militia?
This is a very controversial thing. A recent Supreme Court decision, a major decision by Mr. Justice Scalia, did interpret this to mean that the right to bear arms is an inherent right. Most of the Supreme Court decisions based on this over the preceding century said that that's not the case, and I tend to agree with the precedents here and not Scalia, because I know what Madison was thinking about here. What Madison was thinking about was the fear of a standing army. Many of the states that had recommended amendments were really calling for some way of being assured that we were not going to have a standing army. That's what this
So it's really about a well-regulated militia more than it is the right to bear arms.
It's an insistence that national defense will be in the hands of militia, not a professional army. By the way, what this means is, like, when we get to the War of 1812, Massachusetts refuses to allow its militia to go outside the borders of Massachusetts.
But it does show how the Constitution is a living, breathing document, because it does legitimately, over the years, become a way to guarantee the right to bear arms, whether or not that's what Madison initially intended, or at least so Scalia and others have interpreted as it's grown. You know what's interesting to me, I've always loved, is the least known of the amendments, perhaps, or one of the least known, is the Amendment 3, which is no soldier shall be in time of peace quartered in any house without the consent of the owner. It's because we had almost a genetic aversion to occupation.
Right, right. That's right. I mean, there's a quartering act passed by the British government in New York in 1766 that allows the British Army to stay anywhere they want to and take your house over. And when they occupied Boston in 1774, the same thing happens. And so this is the fear that, they're remembering the Revolution. They're remembering the way in which the British Army imposed itself. I think when, this is perhaps controversial, when the government of Afghanistan says, we want you out, they're talking about the same fear of an occupying army.
That is why it's important, because we sort of understand that we don't like occupations, and yet, we've had to occasionally wrestle with that when it comes to ordering our troops in other countries.
It's one of the reasons we don't do it well.
We don't do exactly right. We're going to move on in the next lesson to some of the other amendments. Thank you very much.
All right.